Okay. Thank you, everybody, for joining us. Um, we'd like to welcome you to a Bridge Legal and HR Solutions webinar. Um, as you may know, Bridge Legal and HR Solutions is a unique consulting firm that brings together employment law and human resources all under one roof. In addition, we also offer workplace investigations, workplace assessments, workplace restoration, and conflict resolution services, among other services that we do offer. We'd like to thank you all for joining us this afternoon. We're going to be discussing some case law that came out last year in 2025, including some slightly earlier case law to set the stage. And we'll be taking you through those decisions and giving you some takeaways from them as well. So, um, just to introduce ourselves, my name is Yandre. I'm an employment lawyer at Bridge Legal and HR Solutions. I handle employment law. I handle human rights, and I also do litigation when that proves to be necessary. And joining me this afternoon is Michelle.
Thanks, Andre. So I'm Michelle. I'm a workplace investigator with Bridge Legal and HR Solutions. I also do training on investigations, on human rights, on discrimination and DEI. And I also do facilitated conversations and workplace assessments. So just a little bit of housekeeping for today's webinar. As you can probably see on your screen, the session is being recorded. A link to the recording will be sent to participants after the webinar is done, and we'll also send out our presentation deck so you have those notes for yourself. All of the cameras and microphones are off just to make sure that everybody can hear us. If you do have questions, and we absolutely welcome your questions, please feel free to make use of the Q&A box. And however much time we have at the end, we're happy to address some of those questions. And we also have live captions available. So you can click Show Captions, the CC button on your Zoom toolbar if you want to follow along with subtitles. And just a quick disclaimer, all of the training materials that we're going to be using today are the property of Bridge Legal and HR Solutions, so please don't copy, share, or otherwise distribute those materials. And of course, nothing in the presentation should be considered to be legal advice. We're kind of talking in generalities today, not about specifics. So if you have specific legal inquiries, please feel free to reach out to us at Bridge Legal, and we'd be happy to help you with that. As a quick overview, today we're going to be talking about some key case law regarding termination clauses that came out in 2025, and Yandre is also going to provide some background information about termination clauses. We're going to talk about a couple of human rights decisions that also came out in 2025, dealing specifically with pregnancy and maternity leave. We're also going to talk about a really interesting case that came out pertaining to off-duty conduct and how that impacts workplace harassment investigations. And we're going to do a very quick update on legislative reminders for 2026 at the end, because there are a few interesting changes that are going to be coming into effect.
Thanks, Michelle. So I'll start us off before we get to the interesting cases that Michelle's going to be discussing. We have to discuss some cases that are just as important, though maybe not as interesting. So just to start setting the stage here for that discussion, I'd like to discuss the concept of reasonable notice, which I'm sure that most of our participants today are aware of. In essence, in Ontario employment law, there are two sources of notice. One is the Employment Standards Act. And most people would know that's the kind of 1 week per year of service up to a maximum of 8 weeks notice scenario. The other one is actually under the common law, and it comes from an old case from the 1960s called Bardell versus Globe and Mail. And in that case, the court determined that there are situations where employees are entitled to notice over and above whatever minimum notice there may be, and it's notice under the common law. In order to determine notice under the common law, the court found that there was 4 key factors to consider. Those are age, years of service, character of employment, availability of comparable employment. And I'll just quickly field a question that just came in about CLC, Canada Labor Code. We're not discussing the Canada Labor Code today. Thank you. While an employee with 8 years of employment may get 8 weeks of notice under the Employment Standards Act, under the common law, they may be entitled to quite a lot more notice than that. Again, taking into account those factors of age, years of service, character of employment, and availability of comparable employment. However, unlike the Employment Standards Act, employers and employees can contract out of the common law by having an enforceable termination clause in an employment agreement. And that enforceable termination clause can do a few things. It can completely eliminate reasonable notice if it is properly written. It can augment the reasonable notice to be whatever notice is agreed upon between the parties, as long as it's not less than minimum notice under the Employment Standards Act. So basically, it gives you some freedom to contract around notice as the employer and the employee. But the key factor is that the termination clause has to be enforceable, because if it is not enforceable, the employee will be entitled to reasonable notice based on the factors that I just described. So going on to the next section, which is about interpretation of termination clauses, as well as the Employment Standards Act. So we all know the ESA, as I just mentioned, as the minimum standards legislation, and 95% of employees in Ontario, other than those covered by the Canada Labour Code, for example, are covered by the Employment Standards Act. Now, employment standards deals with overtime, with limits on hours of work, with vacation, all kinds of matters that kind of set the minimum standard out of which employers and employees cannot contract. Over the decades, courts in Ontario have developed principles on how to interpret both the Employment Standards Act as well as how to interpret the termination clauses in agreements and how those kinds of interpretations work together. In essence, because the Employment Standards Act is what's known as a remedial legislation, that is to say, legislation that cures certain breaches, the courts recognize that this legislation suggests that there's a power imbalance between employers and employees, where the employee needs more protection than the employer, given that the law sets minimum standards for employees rather than minimum standards for employers, whatever that might mean. Recognizing that power imbalance has been very important in kind of the development of where the common law went with termination clause and what we'll be talking about today. Basically, the court said that the Employment Standards Act must be interpreted as broadly as possible to protect as many employees as possible, to the extent that the language, of course, of the Employment Standards Act allows. And the termination clauses, at the same time, must also be interpreted in a way that encourages employers to draft employment agreements that are compliant with the Employment Standards Act. And really where that comes into it is around termination, right, for our purposes today. You cannot put a clause in your contract that says you will not get overtime if you're entitled to overtime, for example. So that would be a violation of the Employment Standards Act. You also cannot put a termination clause that says you will get no notice ever in your employment agreement, because that would also violate the Employment Standards Act. Now, those examples are very simple examples. What we'll be dealing with today are slightly more complex iterations on that theme. So it all sounds well and good, right? Employers and employees can sit down and draft a contract that limits the termination entitlements of the employee to only the minimum standards, and go from that point. But it's not as simple as it seems, because as of 2020 in particular, with the case of Waxdale and Swagan, there's been a lot of churn in what is considered an enforceable termination clause and what is not considered an enforceable termination clause. So we'll talk about Waxdale and one more other case prior to 2025, just so you can see kind of how this led into what happened in 2025. So in 2020, there was this case where the employment agreement provided that the employee could be terminated with just cause without any notice. And most employers at the time in 2020, and perhaps some even today, believe that this is the case. If you have just cause, you can terminate without notice, including ESA notice, no notice whatsoever. The employer in this case, and this is really important to know, is that the employer terminated without cause. So they did not rely on the just cause termination clause in this case. In court, the employer argued that there were two termination clauses here, two separate clauses, one without cause and one with cause, and you need to read them separately. And they argued that even if the just cause termination clause was enforceable, the without cause termination clause is enforceable, even though just cause was unenforceable, the without cause was still enforceable. So the employer asked the court to uphold that termination clause because the employer did not rely on the just cause termination clause. The court did not agree with that argument. In fact, what the court said was termination clauses cannot be read separately. They must all be read together. Basically, there's the principle that termination clauses need to be interpreted as a whole in order to encourage employers to comply with the Employment Standards Act. In essence, you can't really read them piecemeal because their compliance is dependent on all of them, not just one part. And the courts didn't want lower courts going in and using a blue or red pencil, wiping out portions of termination clauses in order to make them enforceable piecemeal, right? Either it's fully enforceable or it's not. That's the basic standard. So the court found that in this case, the termination clause the with cause termination clause permitted no notice termination was unenforceable, and that the employer, in attempting to limit the employee's entitlements to the ESA minimums, went too far and violated the Employment Standards Act. Why? That's because the Employment Standards Act actually has a different standard for judging whether or not an employee is entitled to notice or not than the common law. We all know just cause at common law, but the concept under the Employment Standards Act is different. It's known as willful misconduct. And willful misconduct is a higher bar than just cause, because you can sometimes have just cause where perhaps the employee didn't intend there to be any bad outcomes or bad scenarios. But for willful misconduct, you need to have an employee who's basically behaving bad on purpose, is the language that the court used. So if an employee is behaving bad on purpose, then you could terminate without any notice. That is willful misconduct. Okay. So the court basically said, okay, well, that's unenforceable. Now the whole termination clause is unenforceable based on those principles. So this employee is actually entitled to reasonable notice. One other thing that the court noted that is also important is that the court said you can't have savings language that will save the termination clause. Savings language is language that says something along the lines of, if your termination entitlements are higher than whatever is in this contract, you under the Employment Standards Act, you're going to get whatever those higher Employment Standards Act entitlements are. Basically, you're saying, regardless of what it says above, you're going to get those minimums anyway. The court said this is not permitted because the employee cannot understand at the start of the employment relationship what their termination entitlements are going to be at the end of the employment relationship. Once again, going to that power imbalance between the parties. So, as I mentioned, the employee ended up being entitled to reasonable notice in this case. And again, still continuing with setting the stage, there was the case in 2024 of Dufault and the Township of Ignis. Now, this case included a termination clause that allowed the employer to terminate without cause an employee at any time and in the employer's sole discretion. You can see the red there highlights on the screen, at its sole discretion at any time. Prior to that decision, and even today, many employment agreements in Ontario contain an entitlement for the employer to terminate an employee at any time. The court said, no, this is not allowed, because you're basically permitting the employer to terminate an employee at any time, including during the time when the employee is on a job protected leave of absence. So we know that maternity leave, parental leave, long-term illness leave, a number of leaves under the Employment Standards Act come with what's known as basically job protection, meaning that you have to be put back to the job that you had or something comparable to that before you went on a leave if you're an employee. By saying that the employee could terminate the employer at any time, in essence, the contract was saying that the employee could be terminated while on one of those job protected leaves, which is illegal. The court found termination clause was unenforceable, and the employee was therefore entitled to reasonable notice. It's notable that the court also found, and this is the lower court in this case, that the just cause termination clause was also unenforceable in this case. So basically, you had a scenario of both clauses being unenforceable. And because of that, this case actually ended up being appealed. The Ontario Court of Appeal looked at the appeal and basically said, well, look, the just cause termination provision is illegal. We know from Waxdale that makes all termination clauses unenforceable. So therefore, we don't need to even look at this language at any time or at its sole discretion. We don't need to look at it at all. So they ignored that and they decided on the basis of the with cause termination clause, same as Waxdale. Well, this was then appealed to the Supreme Court, and very helpfully, the Supreme Court basically said, we're not going to look at this either. So that kind of left the matter kind of uncertain. It seemed like if you have language that says that you can terminate employees at any time, it is in fact unenforceable language that needs to be corrected. Okay. So after these cases came down, everybody was looking at 2025 and what are the principles that we know in terms of making an enforceable termination clause now. And we knew that all termination clauses must be enforceable or they'll all be thrown out. So you can't have one unenforceable or another unenforceable. By the way, this might include probationary period clauses and other clauses that are meant to be termination clauses. So anything that's a termination clause, it has to be read together and it all has to be enforceable. And it doesn't matter where in the contract it is as well, by the way. They'll all be read together, even if they're 10 pages apart. Savings and severing language will not save an illegal termination clause, as I mentioned. So you can't say you'll get the minimums if this is illegal, right? You can't say that. That's not going to save you. Cause provisions cannot allow for termination without notice under the ESA. Termination clauses cannot allow for termination at any time, and termination clauses cannot allow for termination in the employer's sole discretion. So these seem like these were principles going into 2025 that we'd really be looking at and that the courts would then be looking at in terms of cases that came down. And in fact, there was quite a bit of litigation about this, and there's three cases that I'd like to discuss now. The first case I'm going to talk about is Baker and Van Dolder's home team, which was decided in early 2025. In essence, there was a contract for the employee that said that the company may terminate your employment at any time. Basically, similar language to what we saw in default, doesn't have the language about discretion. So the default case was at play, and the employer argued that there was a difference, right? The employer wanted to uphold the clause, and the employer said, well, there's a difference in default because that case had the sole discretion of the employer, and this contract doesn't have sole discretion of the employer. It only says at any time. The court did not agree with that argument. The court said that at any time language is offside because of what default decided. Basically, the court said it'll follow default in this case. Now, what happened was this case was actually appealed, and we were looking forward to arguments to actually start on January 16th of this year, 2026. It's actually been postponed. It's adjourned until March 25th, 2026 is my understanding is when this is going to take place, the appeal. So we may, by the latter half of this year, get an outcome in this case. After Baker, Jones and Strides also came out, the decision. Interestingly, Baker had already been decided and it was already out. And that is important here for a particular reason. But in this case, the termination clause also permitted termination at any time without cause. Basically, without the discretionary language, it was at any time. The court looked at the termination clause and found it was enforceable because it did not have the sole discretion language, which the default case had. So the court basically said that the case of default does not stand for the proposition that the words at any time can be divorced from the words sole discretion. Basically, it does not stand for that. Just having the one was sufficient here to keep the contract enforceable. So this is the exact opposite outcome in Baker, which is highly confusing because the language is almost identical of the two clauses. Now, as I mentioned before, the Baker case had already been decided by this point. And even though it was already out, there was no argument from the employee council about Baker, and they did not bring Baker up, which is interesting. I'm not sure why they didn't do that. And it doesn't appear that the employee appealed this decision, so there's not going to be any further details coming out about Jones and Strides. With that said, also in 2025, we had Lee and Wayfair Canada come down. And that was a situation where the court, again, they read the termination clause as a whole, and the termination clause stated that the employee may be terminated at any time and for any reason, but also contained numerous references to guaranteed payments under the Employment Standards Act. And the court looked at this very carefully and said, well, look, in many, many instances in this contract, including in the termination clauses, the employer is saying that at all times, all payments required by the Employment Standards Act will be made. And the court said that because of these consistent references, There's actually no attempt at all by the employer here to contract out of the Employment Standards Act. They're only contracting out of the common law, which is permitted, as I mentioned. So therefore, the clause was upheld. There's no violation of the Employment Standards Act. Clause is upheld. And again, not clear why one case went one way and the other case went the other way, other than this apparent savings type sounding language of you'll be getting your Employment Standards Act minimums in all cases. As with the Baker case, this case was also appealed. And as with the Baker case, the appeal was adjourned and it's going ahead, I believe, in March as well. So again, another situation where we're probably going to get more clear answers by the end of this year. So stay tuned on that. We'll see where this goes, and we'll let you know when those appeals come down, because it is likely going to affect how we draft termination clauses going forward. So in 2026, that is to say now, the situation is a little bit more muddled. Some of the principles remain, others became somewhat unclear. The first three principles, those are the principles that really came out of the case of Waxdale. Those still remain. It's really what happened with default that's a bit not settled. So we're not sure if at any time language is permitted based on court decisions so far, given that they have been somewhat all over the place. And we're not sure what in the employer's sole discretion language would do to a termination clause that is otherwise enforceable. It's not clear. So this is why it's important for us to get those decisions this year and to get some clarity over where termination clauses are going. So at the start of 2026, what are kind of the key takeaways? I mean, the one takeaway is that it's getting more difficult to write enforceable termination clauses, just generally speaking, and it seems like courts will find ways to overrule them from time to time. So if you have not updated your employment agreements in the last year or two or four or however many years it might have been, you definitely want to look now and check what your termination clauses look like and give us a call. We're more than happy to assist. We'll have our number and email up on the screen later to review those contracts for you. Again, key takeaways are if your employment agreement permits termination without notice for cause, the termination clauses will likely be unenforceable and you should review those immediately. Like those are already unenforceable. If your employment agreement permits termination at any time, there's a chance that it's unenforceable and should be reviewed. Again, it's sometimes difficult to change contracts that are already in place. So perhaps you already have some old contracts that use that language. If you want to give an employee a new contract, you typically need to provide additional consideration. That's to say some kind of payment or other benefit to do so. That can be difficult, but I would recommend to keep an eye out. And if the case law comes down that the language at any time is definitely unenforceable, then you definitely want to go to update those termination clauses. Finally, as I mentioned, keep an eye out on the Court of Appeal for those decisions in Baker and Lee. That's going to clarify a lot of the confusion that we experienced at the start of this year. And Michelle is now going to take over to chat about some more factually interesting cases. Let's put it that way.
Thanks, Yandre. I found that very factually interesting, but thank you for that. So we're going to talk a little bit about some human rights cases that came out in 2025, and then a case dealing with workplace harassment towards the end. So we're going to be talking about two cases, the Lee case and the Lamb case. Both of these dealt with pregnancy and maternity leave, which is interesting because we don't have a ton of cases at the HRTO dealing with that particular issue. So it was nice to see two cases coming out in 2025 to give some guidance on how employers can do, or more specifically, what they should not do when it comes to employees who are going on maternity leave. So the first case we're going to talk about is the Lee case. In this case, we had the applicant who was an employee who'd been with the organization for 12 years, so quite a long-term employee. And in 2016, the applicant was on a one-year maternity leave. Interestingly, the respondent, who's the employer, contacted her 3 months into the leave to ask if she planned to come back. Which is a little unusual. Usually when employees are on a leave, we sort of assume they're coming back during the established time. So that was a little bit strange. The bigger issue happened right before the applicant returned to work in 2017. So her employer contacted her to advise that her hours had been changed. And they'd been changed quite significantly. She went from a 9 to 5, 4-day-a-week schedule to a 9 to 6, 5-day-a-week schedule. So we're talking roughly 30 hours to 45 hours. Quite a significant change. Done unilaterally without any kind of consultation with someone who was on a maternity leave, clearly had childcare obligations that they had to consider as well. So that was definitely not a great thing to be happening to that employee. The applicant also alleged that when she returned, she was given a number of new duties that she was not trained on, and that she was then berated for not being able to complete those duties. So, a very difficult, toxic work environment for her. She was also placed on a temporary layoff in early 2017, and the employee who had been covering her job was given her duties. So she was essentially replaced, and then she was then moved to a different location that didn't work well for her. At that point, she resigned. She felt the work situation was not tenable for her. And she made an application with the Human Rights Tribunal alleging discrimination on the basis of sex and family status. She also had another application, an ESA complaint to the Ministry of Labor, alleging constructive dismissal. So she had that process going on. It was found that she was constructively dismissed, and she was awarded around $6,000 in termination pay. So when the matter got to the Human Rights Tribunal, they had to consider that other process as well, and whether specifically the human rights grounds were considered by the Employment Standards Officer, and they found that they were not. The Employment Standards Officer was quite clear that the human rights issues were not dealt with in the ESA complaint, which meant that she could also have her proceedings at the Human Rights Tribunal go ahead. The Human Rights Tribunal found that the employer did discriminate against the applicant, not surprising given all the things that we heard. And she was awarded lost wages and $20,000 for injury to dignity, feelings, and self-respect. That's quite a high award. The Human Rights Tribunal is not known for particularly high awards compared to courts, for example. But she was given $20,000. And in considering that relatively high award, the HRTO looked at the fact that this was a dismissal. So officially she resigned, but then through the ESA complaint, it was found that she was constructively dismissed. So it was a dismissal. We're not just talking about comments or, a slightly uncomfortable work environment. We're talking about a loss of her livelihood, which is very serious. They also looked at the impact on the applicant. So this was a 12-year employee. This was someone who was very entrenched in that workplace. This was someone who testified that she experienced a great deal of anxiety and depression and worry about trying to support her family and trying to find childcare. So because of those things, the fact that it was a dismissal and the impact on the applicant, we have that high award. And again, that was on top of lost wages in the amount of, I think, $23,000 and the $6,000 in termination pay. So we're looking at upwards of $50,000 to this applicant. So very high award. What employers can maybe take away from this are a few things. The tribunal is going to treat any return from leave situation as a highly vulnerable moment for an employee. It is difficult, regardless of why an employee was off work, to come back into the workplace. And so there should be a degree of respect and a degree of accommodation given to that employee, which did not happen in this case. The tribunal is always going to scrutinize any unilateral changes to an employee's hours or to their job duties. In this case, it was both, particularly when they take place very close to when an employee returns to work. That's a time when employers want to be very careful what they do with an employee's hours and an employee's job duties, and that you should be engaging as an employer in a dialogue with that employee about what works for them and whether or not they need any accommodations. The HRTO does not want to see employers treating a maternity leave as an excuse or an opportunity to restructure someone's role. Perhaps most importantly for anyone wanting to mitigate litigation risk is keep in mind that there can be multiple proceedings coming out of one situation. So this employee got to both do their ESA complaint and their HRTO matter because they cover different things. So the amounts that you're looking at in terms of payout can be quite high given the multiple proceedings that can be taking place. And finally, the employer did not participate in this particular process. So hopefully this goes without saying, but employers should very strongly consider participating in an HRTO process. because we are seeing higher and higher awards, and also because of the fact that these decisions are public. There could be a lot of reputational damage that can come to an employer through a process like this. So very much a good idea to participate in the process, because otherwise the HRTO is going to make the decision based solely on what the employee tells them. So the next case that we're going to look at is the Lamb case. And as I mentioned, this is also a case of a pregnancy maternity leave situation. In this case, we had an employee who was a short-term employee. So in Lee, it was a 12-year employee. In this case, we have an employee who was still on probation at the time they announced their pregnancy. She'd been there about 6 months. The applicant alleged that after telling her employer that she was pregnant and that she would be taking her maternity leave, she was penalized in a variety of ways. So firstly, she was denied a training opportunity that her coworkers were allowed to participate in. And she was actually specifically told by her manager that if she had not told them she was leaving, she would have been permitted to participate in that training, essentially saying it was a waste of time to train her because she was no longer going to be there. So they were very open about that. She was also subjected to sexualized comments about her pregnancy to the effect of she should have kept her legs closed and not gotten pregnant. Really disgusting, vulgar things to be saying to anybody, really, but especially to an employee. And around the same time, she was also receiving negative comments about her place of origin, which I believe was Hong Kong, from that same manager, saying that she was not a good worker and was not trustworthy because of that place of origin. So a lot of really negative, really toxic, harassing comments were coming her way. Shortly after she announced her pregnancy, she was at the end of her probationary period and inquired about becoming a permanent employee, and that was denied. Again, the manager was very open about why that was, saying, I believe you're just going to go off on maternity leave and not come back, so we're not going to take you off your probationary period. There wasn't really any need to guess why that happened. And then eventually she was terminated. And the termination was done in quite an insensitive manner. The employee came into work to find that their desk was cleared off, everything was packed up. They were handed a termination letter. They were told it was for a genuine business reason, for budgetary reasons, but the employee did not believe that for obvious reasons. And the tribunal didn't either. The tribunal found that the applicant's pregnancy was a significant factor in her termination. And we know at the HRTO that it doesn't have to be the only reason. There might have also been business reasons behind it. But as long as the code-related ground is a factor, the HRTO is going to find in favor of the applicant. They also found that the applicant was subjected to workplace sexual harassment because of that vulgar comment that the manager made. This case came out after Lee, the last case that we looked at. So the HRTO did consider Lee when they were deciding the amount of the award for this applicant. And maybe somewhat surprisingly, they came to a higher award. So in Lee, we had $20,000 for injury to dignity, feelings, and self-respect. In Lamb, we're seeing $25,000. Again, a very high award for injury to dignity, feelings, and self-respect. And the HRTO parsed that out in kind of an interesting way. So the award for the pregnancy-related termination was actually lower than Lee. It was $17,500. But they gave Lamb a separate award for the other grounds, for the sexual harassment because of the vulgar commentary and for the comments about place of origin. So she received an additional $7,500 on top of that for the total $25,000 award. So that's something to keep in mind as well, is the idea that at the HRTO, if there's multiple grounds of discrimination or harassment, you can find those awards getting stacked for an ultimate higher award. So this case is interesting for a couple of reasons. One of those is that this was, again, a probationary employee. And so it's very important for employers to remember that even short-term probationary employees have the same protections under the Human Rights Code as longer-term employees. Every employee deserves to be treated with dignity and respect, even if they are a probationary employee. It also gives a really good idea of certain things that managers, supervisors, anyone in a position of authority should be trained on. This manager made a lot of really egregious comments, very much should have known better given their position. So when an employee has disclosed a pregnancy, will be going on a maternity leave, that has to be dealt with a very high degree of sensitivity. And there should never be any indication that anything negative will be happening to that employee, that they'll be denied any opportunities as a result of disclosing that pregnancy or going on maternity leave. So the last thing we're going to talk about is the Metrolinx case. And we were really interested to see this coming out because specifically it deals with off-duty conduct, which is something that we get a fair bit of questions about. We often have employers asking what can be done or what should be done with discussions, gatherings, social media, anything that happens outside of the actual workspace, because obviously managers, supervisors have limited control over what employees do on their off-duty time. So Metrolinx gives us some good guidance about that. So in Metrolinx, we had a group of workers who were found to be texting via WhatsApp, and this was on their personal cell phones on their personal time. And in this text message chain, they made some very derogatory, sexist, negative comments about other employees. One of the text messages in particular was alleging that a female employee was performing sexual favors in order to advance at work. So a very gross, very stereotypical comment that might be made in a workplace. That employee eventually found out about the situation and she reported it to a supervisor, but she was very clear that she did not want to file a formal complaint. Eventually, the Human Resources Department did discover that the text messages existed and decided to investigate. And after they did so, they put together their report. They found the employees did engage in sexual harassment and the employees were terminated. The employees put in a grievance and it went to arbitration. And the arbitrator agreed with the employees. They found that they should be reinstated and they should be given back pay. So the arbitrator's reasoning for that, there was a few reasons. First, they pointed out the fact that the grievers intended for that text message chain to remain private. It was not something they were advertising around work. It was not something they wanted anybody to see. It was just supposed to remain between them, and for the arbitrator, that took it outside the realm of being a work-related issue. The arbitrator also noted that the employee in question, she was referred to as Ms. A, the one who was the subject of the text messages, did not make a complaint. And in the arbitrator's eyes, that sort of put the employer in the position of being both the complainant and the investigator, which they felt brought up an appearance of bias and fairness to the respondents. And the arbitrator also noted that because Ms. A had not put in a complaint, that would indicate that she did not fully feel or believe that she was being sexually harassed in the workplace. So that was the arbitrator's reasoning. The divisional court did not agree. And personally, I don't agree either. I think a lot of people were kind of surprised by that arbitrator's decision. So the divisional court, in reviewing that decision, decided to quash it for a few reasons. First, they found that the arbitrator failed to consider the employer's obligations under the Occupational Health and Safety Act to investigate not just complaints of harassment, but also incidents. And the distinction there is that there does not have to be a formal complaint in order for an employer to investigate. If a matter comes to an employer's attention, and that could be through a supervisor, a manager, HR, if it comes to their attention that harassment might be happening, there is a duty to investigate whether there's a complaint or not. The divisional court also found that the arbitrator placed too much focus on the lack of the complaint by Ms. A and what that meant. The arbitrator engaged in some very stereotypical thinking around what it means when someone doesn't complain. They assumed this meant that Ms. A was not bothered or didn't feel that she was being sexually harassed, when in fact we know there's a lot of reasons why someone might not complain about sexual harassment. They might find it embarrassing. They might not think anything will be done. They might just not want to rock the boat or be seen as a complainer in the workplace. So there's a lot of reasons, and that assumption that she was not bothered or didn't feel harassed was erroneous. It was not a good basis for the decision. And it was also found that the arbitrator wrongly labeled the conduct as being off-duty or irrelevant conduct to the workplace. I think we've come a long way in the last few years about how we look at what it means for conduct to be work-related. It's not so much whether it takes place between 9 and 5 within the workplace. Really, the key is how does it impact the workplace? So when it came to this, these were employees talking amongst each other about another employee, alleging that this employee had engaged in sexual conduct to advance at work. All of that is work-related. And even if they did not intend for that to get out, there was always a possibility that it would. It was reasonably foreseeable that that would create a negative, uncomfortable environment for Ms. A, and that brings it within the realm of work-related conduct. The divisional court's decision was then appealed to the Court of Appeal, and the Court of Appeal agreed. So I think we can accept that this is really the state of the law right now in terms of what it means for conduct to be off-duty or work-related. So key takeaways from this case, employers have an obligation to investigate workplace harassment even without a formal complaint. You don't have to wait for someone to put in a complaint form or anything like that. If it is known that harassment might be happening, there is a duty to investigate. Employees harassing other employees outside of the workplace, and that could be on personal devices, text messages, social media, at after work drinks, whatever it is, that also can activate the employer's duty to investigate if that behavior could reasonably be seen to have an impact on the workplace. And very notably, there's a recent amendment to the Occupational Health and Safety Act that specifically added language to the definition of harassment, and it defines harassment as including virtually through the use of information and communications technology. So it's very explicit. Harassment looks different in 2026 than maybe it did back when that section was first drafted. Now, Yandere is going to talk to us a little bit with some legislative reminders for 2026.
Thanks very much, Michelle. So there are a couple of things to be aware of coming into effect this year. One has already come into effect January 1st, 2026. So I'm sure many of you have already seen this, but if you are an employer with 25 or more employees and you are posting public job postings, there are certain items that you need to include. There must be the inclusion of expected compensation. You can include a range of compensation as long as that range does not exceed $50,000. You have to disclose if you use AI to determine candidates. And there's also needs to be a statement of whether a vacancy actually exists for the job that you are trying to fill or not. And there's a couple of other requirements, including a certain duration of time before you have to reach out to candidates who did apply to the job, as well as document retention for a period of 3 years in respect of interviews and job applications. So there are these requirements that you need to be aware of. If your job posting does not meet them, it can be flagged. So review everything, basically. The other is to be decided at the moment. It's whenever it's proclaimed by the Lieutenant Governor. It's the placement of a child leave. Basically, it's a new leave for employees who have a child placed in their home. To qualify, the employee needs to be employed for a period of 13 weeks, which is quite similar to some of the other leaves, by the way. And the maximum duration of the leave is 16 weeks. Again, that's not yet in effect, but if it does come into effect at some point this year, which is very likely, you'll want to update your handbooks or any kind of other documents you have that purport to be a comprehensive list of all leaves, because this needs to also be now included in that list. And I think with that, we're coming to the end of our substantive portion, and now we have time for some questions. There's a few in the Q&A, which I will ask now, and I may answer these, some maybe for Michelle, which I will ask Michelle. Okay, actually, this one's for Michelle, and since Michelle just spoke, I might as well ask Michelle right away. If the applicant doesn't participate, like in the Metrolinx case, how do you go about doing an investigation, and do you still have to do one?
Yeah, you do still have to do one, absolutely. And the answer is it can be difficult. We can acknowledge that when the applicant or the complainant is not participating, maybe not only didn't put in a complaint, but doesn't want to participate in the investigation, it can be really tough. We know that in Ontario, at least under the Occupational Health and Safety Act, we need to conduct an investigation that is appropriate in the circumstances. So really the question would be, what would be an appropriate investigation? What information can you gather? If it's come to your attention there might be harassment, you have to turn your mind to what other evidence can I potentially get if the complainant's not talking to me? Were there potentially witnesses? Are there documents? Were there maybe emails exchanged that I can retrieve? So whatever can be done should be done. As long as the employer is doing their best to gather the information in the absence of the complainant, that would likely be found to be an investigation that's appropriate in the circumstances, but would not be appropriate to just ignore the matter because the complainant doesn't want to participate.
Right. I mean, still an occupational health and safety requirement at the core of it, right? Um,
Absolutely.
Now, there's a few questions that I think I will field here right now. One question is, when does the new leave come into effect? That is the leave I just mentioned. As I mentioned, that leave does not come into effect until a date that it is proclaimed by the Lieutenant Governor of Ontario, which we don't know what date that is. So the answer is we don't know, most likely in 2026 on a date to be announced. Um, the next question I have here is about the captions, whether the caption text can be shared. I will check, and if that is possible, it will be. If that is not possible, it won't be. Um, Another question we have here is if your termination clause has 2 weeks notice, should your employment agreement termination clause have a disclaimer that depending on years of service, 2 weeks may be different? Just wondering, well, that sounds unenforceable right there because 2 weeks without any statement that it'll increase based on the Employment Standards Act would make that unenforceable right there. You can't have 2 weeks only. And you don't need a disclaimer, you need a proper termination clause. Um, uh, Going further, if our agreements say at any time right now, should it be changed? And if our termination clause says that the employee can be terminated immediately, is that unenforceable? I mean, if you have at any time, I mean, definitely have a look. It may need to be updated, something that you can reach out to us. I think our phone number there, 647-794-5442. More happy to schedule a time to discuss any employment agreements and any changes that may need to be made to employment agreements. So at any time language, again, it may be fine by the end of this year, but in my opinion, it's an easy fix. Just remove that language in most cases, and perhaps the termination clause is good unless there's something else that makes it unenforceable. Another one, as I mentioned, was whether or not immediately makes it unenforceable. I haven't seen immediately come up in this manner in case law yet. I'm curious if the Ontario Court of Appeal decides that at any time language is good enough to make a termination clause unenforceable. I don't know, maybe immediately is similar to at any time. That is something that I think we need to get more details from the court to actually answer properly. Another question here is, are employers obligated to update their handbook every time leave legislation changes, or is it acceptable to rely on the assumption employees are entitled to all ESA benefits, even if it's explicitly restated in the handbook? The answer is you don't have to list all the leaves in your handbook. My advice to updating your handbook is if you already have all the leaves listed. Because if you have your leaves listed and you basically tell employees these are all the leaves that you get under the Employment Standards Act, well, then it's not true, and your handbook is actually not in line with what the Employment Standards Acts require. If you just have a statement in your employment handbook that says you get all the leaves permitted under the ESA, well, there's not much you can change there. The only issue you'll have is employees will need to go to the Ministry of Labor website to actually find out what are the leaves and what are my entitlements and what are the requirements, which sometimes the handbook is helpful in that and having everything set out there. The employees don't go to the Ministry of Labor website, for one, but also it allows you as well to have certain procedures about how leaves can be utilized. For example, who does the employee go to request a leave? What information do they need for specific types of leave without the employee having to dig to find that information? So I think, depends on what your handbook looks like. Maybe you do need to update it. Maybe you don't. And if I'm correct here, that is all of the questions that we have. I do want to actually go back to the Canada Labor Code question just quickly. The reasonable notice standards that I talked about, they apply to federal employees as much as they do to Ontario employees. The difference is that how you draft a federal termination clause is going to differ from how you draft a termination clause. In Ontario, you still need to have an enforceable termination clause, federally speaking, to limit the employee to Canada Labor Code standards only. So that principle is basically the same. Okay, so I think that actually covers everything. I think we have one more slide with the contact info or something like that to make it a little bit easier for everybody to read. So you can, of course, email us info@bridgelegalhr.ca. You can also call us at 647-794-5442. We're more than happy to assist you with reviewing contracts or whatever else you need. Michelle, thank you very much.
Thanks, Andre. And thank you
And
everyone for joining us.
thank you, everybody. Have a great rest of your day.